Talapatra, Judge, High Court of Tripura, and Honorable Mr. Justice Arindam Lodh, Judge in Charge, Tripura Judicial Academy, to kindly take their respective seats on the dais. Thank you, Lordship. Case management resulting in reduction of pendency. Additionally, with quality disposal has always been a topic of discussion. Since the last many decades, the jurists have mooted several strategies to tackle the issue of delays and pendency in India. There is no doubt that positive actions are taken not only from our legislators but as well as the judiciary. Changes like amendment of the procedural law, setting up of several tribunals, experimenting with alternate dispute resolution mechanism like mediation centers at several district courts level have already been incorporated. One of the most innovative introduction to the scheme probably would be the impetus which is given to computerization. At this point, reference can be made to the judgment of the Honorable Apex Court delivered in Imtiaz Ahmed versus State of Uttar Pradesh in the year 2017, whereby the suggestion of NCMS, National Court Management System, regarding pendency has been considered and specific directions were given to all the high courts to evolve a system of uniform data collection and management methods regarding number of cases pending, instituted, and disposed. Our speakers for this session, Honorable Mr. Justice Subhashis Talapatra, Judge, High Court of Tripura, after completion of his studies, got enrolled as an advocate in the year 1990 and appeared in several constitutional, civil, and criminal matters. Lordship got designated as senior counsel in the year 2004 and thereafter got elevated as Judge, Guwahati High Court in the year 2011. The other esteemed speaker of this session, Honorable Mr. Justice Arindam Lodh, got enrolled as an advocate in the year 1988 and continued his practice until his elevation in the year 2018 as Judge, High Court of Tripura. I would request at first Honorable Mr. Justice Arindam Lodh, Judge, High Court of Tripura, to present his deliberation on the topic.
Good morning to all of you. Honorable Justice Sri Subhashis Talapatra, Judge Guwahati High Court of Tripura. My brother colleague, Justice Chattopadhyay, Judge High Court of Tripura. My brothers and sisters of this judicial institution. Today, the topic is case management, quality disposal, and pendency. Actually, case management is a judicial process where we have to handle the cases from the very beginning. We have to make our plan, a specific plan, how to deal a particular case and how to deal the issues related to the case. Now, in doing so, suppose I am giving some examples. In civil cases, what we see. Just I will discuss some basic questions, basic issues. Elaborately, it will be discussed by my brother judge, who has vast experience on this topic. Basic points which I felt during my professional life and also after elevation as a judge, that in civil cases we see a plaint is filed. First, a case is instituted with the filing of a plaint. The party which files the plaint is called as plaintiff. After filing of the plaint, it is checked by our concerned officer. I think it is Shersadar. So he will check up the entire plaint, whether it is in form and whether it is within limitation. Thereafter, he will make a report. That report, along with the plaint, will come to the officer, presiding officer, the judge of this court. Now, here, according to me, which I feel, just after receipt of this plaint, as a judge, I think, you are also the judge, that we should go through the plaint. The issues raised, we shall try to identify the controversies raised in the plaint. Thereafter, the next stage, issuing of summons. Summons are issued. Now, who issues the summons? Our process servers. They issue the summons. Sometimes we get the reports, address is not available. It returns with the remark wrong address, not found. These type of remarks. Here I feel we have a role. We are to monitor and supervise that process servers, whether they really goes to the place, the house of the address. So it is also a kind of case management. To monitor, to make a supervision over the process servers. Next, suppose process is served, the defendant, the opposite party is called the defendant. Now, defendant receives a notice and he appears before the court. On the first day, what experience we have gathered, we file vakalatnama only. And we do not file written statement. I have seen in my professional life that many advocates also prepare written statement, but they will keep it in their files. They will not file it. There may be some purpose. At this stage, when he appears by filing Bhagalatnama, we can call the advocate, learned advocate, the lawyer of the defendant. Please come. Then you have filed Bhagalatnama today. You have not filed written statement. Have you gone through the written statement? We may ask. He may say no. He may say yes. If he says yes, then we request him. You have gone through the plaint and you have something you have in your mind. So please file the written statement as early as possible. And please tell me your convenient date. Why we shall ask him from him we want to know his convenient date? For the reason that by the next date, what he will propose, he will file the written statement. Generally, written statement, is to be filed within so and so, and by these 90 days, and thereafter also time is sought for, application is filed that to accept the written statement. Many courts, the trial courts reject the prayer. No, time barred, within time, prescribed in CPC you have not filed, so no, I will not accept it. Then revision comes, we entertain revision, and okay, to render justice, okay, justice should be equitous, so we direct the trial court, okay, you accept the written statement and proceed with the trial. So we can avoid this thing, that a revision, reject, okay. So what I wanted to point out, that from his mouth, please tell me your convenient date of filing written statement. In this way, it is also, in my opinion, is a part of our case management. Because it should be, case management means what? We are to file, we are to be, we are to render effective, efficacious. Object is, main purpose is expeditious disposal to reduce the pendency. Now, so with those objects in mind, we have to plan ourselves how to reduce, how to make short the thing, and to simplify the matters without inviting complications. So suppose a written statement has been filed on the next date, then the judge can sit with them, the lawyers of both the parties. Now you have filed written statement. As a defendant lawyer, you have identified your problems, the issues raised, and how to object it, and how you have dealt with the plaintiff assertions. Then you may ask the plaintiff, these are the answers he has given. This is the way he has dealt with the issues. The plaint you have averred in the plaint. What do you like? Then now CPC empowered us to have a resolution, alternative disputes resolution. So the issues should be maybe resolved out of the court before entering into trial. So if the plaintiff and both the plaintiffs and defendant agrees that okay, let us try, then we have a judge himself can take the initiative, or he can send the matter to mediator or conciliator, anything, to mediate the disputes, whether there is any scope to explore the possibilities of resolution raised in the plaint and as well as in the written statement. If the matter is resolved, then you have acquired a great success. At the very initial stage, without even going into the entering into the trial, parties have settled their disputes. A decree will be passed on the basis of the amicable settlement, and it will form as a part of the decree. So in this way, we can resolve the disputes. Suppose mediation and efforts to mitigate the thing, mitigate the case, fails, then the issues has to be framed. Now, maximum time, what my experience in professional, we never used to file draft issues. Very rarely we used to file. It is the court, actually duties are also upon the court to frame issues. Here we face problem. In my opinion, we should request the lawyers, learned lawyers, to file draft issues, proposed issues, on the basis of which the the case will proceed. Why I am saying so? Many a times in the High Court we have seen that the lawyers argue the court did not frame this issue. Yes, but this is a vital question. Suppose question of limitation. You know, limitation is a mixed question of facts and law. But limitation will be a substantial question of law. When it enters, it affects the very root of the case. When it is found, then we have no other alternative but to remit the case again to the trial court, directing the trial court to frame the issue on limitation. And so many, so this is one of the examples. Now, so the judges should sit on the safe side. Okay, you submit the proposed issues. So it is also a kind of integral part of case management. Now, the issues have been framed. The trial will proceed. The trial witnesses will come. The plaintiff will file. Now, examination in chief is filed under Order 18 Rule 4. And then cross-examination. On the day, ordinarily we see, on the day cross-examination is not made, because after submitting examination in chief, serving a copy upon the other side, next date is fixed for cross-examination. Now, suppose witnesses appear before the court, and court is also ready. We all are ready to cross-examine the witnesses. Now, defendant side may seek adjournment. Okay, I am not ready, I am not prepared. The lawyer is ill. If the lawyer is ill, then question may be otherwise. Because no court should avoid disputes with the lawyers. The lawyers also are the officers of the court. We should keep it in our mind. So, but other grounds, suppose here you have to tackle the situation. Lawyer is present, witnesses are present, plaintiff is present, defendant will cross-examine. You try to persuade the counsel appearing for the defendant that, look, Mr. So-and-so, witnesses are present, so please cross-examine. And my suggestion would be that when the witnesses in attendance, they must be examined. Lawyers also present, witnesses also in attendance. We are to insist the lawyers of the other side to cross-examine. And otherwise, on flimsy ground, we should not adjourn the case. And if we are compelled to adjourn the case, heavy cost is to be imposed. If you find that there is no other alternative, the situation is so we cannot avoid, okay, but a minimum cost may be imposed. So, or one thing also on the very first date, you can also, after considering the situation of the court and situation of the case. So this is the thing. So here you have to manage. Here you have to tackle the manage the situation, the complications which will which may come forward, which you may have to face. Now, during examination, which sometimes we find that a counsel, out of maybe out of ignorance or anything else, the question he files some document. In some cases, we find photocopy of this of a sale deed or gift deed or will is submitted, or any document. The photocopy means, or certified copy of the original means secondary evidence. So sitting here, we have seen that this photocopy or certified copy without any further examination or without compliance of the provisions of Evidence Act 6768, this it is exhibited, marked as exhibit. Then question second appeal, first appeal also avoids this, did not notice it. Then question comes up before us. This is the court, how the court has made it exhibited. No evidence, nothing else. Procedure has not been followed. And we find, yes, procedure has not been followed. The certified copy has been without any examination, without uh, exhausting the procedure as emphasized in section 68, 67. Yes, it has been exhibited. The sub-register is to be called, the witnesses has to be called. So these are the things we have to keep in mind. That certified copy, if secondary evidence is produced, the court should ask the learned counsels that what is the problem. Because to produce certified copy or photocopy of a document, first you have to lay a foundation why you are producing secondary evidence. Why is the original of the photocopy or certified copy, and under what circumstances you have produced the photocopy. He is to satisfy the court that yes, for these are the reasons, these are the foundations why I could not file, or I am filing certified copy or photocopy. So then we have to follow section 65 of the Evidence Act. Whether these are the ways how a photocopy or certified, everybody you know. But these are the procedure you have to exhaust at this stage, so that complications, we are not to face the complications on this issue, that yes, it has not been dealt with. Why I am saying this? Because we are regularly we are experiencing this thing, that documents are marked but not exhibited, but not in accordance with law. So these are the things we have to keep notice. Few days back, I dealt with a case where I categorically discussed this thing. These are to be observed, and I requested my director to circulate the copy of this judgment, so that all our judicial officers can take a notice of this, to exhaust the procedure as laid down under the provisions of the Evidence Act. In this, why I am saying so? In this way, we are to shorten. We can shorten the litigation. This point may not come up before the High Court in second appeal. It could be ended here in your court itself, in the first appeal itself. Why the litigants come to the court? Why we have expanded the number of courts? To dispose of the case, to give relief to the litigants as early as possible, expeditiously. efficaciously. Now the question. So another thing I like to tell you, that even a secondary evidence is produced, objection may be given by the learned counsel of the opposite side, of the other side. And many a times we find that the uh, the party of other side did not raise any objection, and court also did not alert the party who produces the secondary evidence. My personal opinion is that here the court has a role, because by this way we can reduce the pendency, we can write a qualitative judgment, because all issues have been dealt with. Now, objection also has to be raised at the very initial stage. We write subject to objection, SO. We mark it SO. And if objection is not raised, it cannot be raised in revision, in appeal, in at the very outset, at the very initial stage of production of this document, we are to raise, the parties to raise objection. The many judges, we may think, yeah, it is not my duty, it is the duty of the, I know the law, you know the law, but in spite of that, okay, it is the duty of the other side to raise objection. Why I draw the attention of the learned counsel? But my opinion is that you please make the lawyer of the other side alert that this is the flaws, this is the loopholes, this is the gap. You are to rectify, you are to cure the defects. A chance should be given to him. If and cure, okay. Because ultimately we are to render justice, equitous justice. Justice must be equitable. And these complications, so that will not come up before the High Court. We can resolve this issue in the level of civil judge, in the level of the court of learned civil judge. So these are the things. By this way, we can also, it will help you to write quality judgment. And also, if the party doesn't file appeal, there is no ground of appeal, it can be disposed of on the very date of filing the appeal. And by this way, it will reduce the pendency of pendency of the cases in a particular court, in first appellate court also, in the second appellate court also. So thereafter, you are to hear the arguments of the parties. They may ask for adjournment again. We have to face so many difficulties at every stages. Lawyers also think practical, that okay, if on the very first day I argue, okay, the client has given me 5,000, okay, if I do not argue the case today, another date I may ask for, okay, then another 5,000. This is the, so these are the things also we we should keep in mind, and tackle the situation, and try to resolve these issues. uh, Here is your intellect and capacity of case management. how you will deal with the situation, how you will convince the lawyers, okay, to participate in the process of argument. You may say him, okay, start the argument. It may be kept part heard. On the other day, I will adjourn the case. If you have face any difficulty, okay, I will adjourn. But you start the argument. Somehow, if you if you are able to convince him to start the argument, then you see he will continue to argue. He will continue to argue. Then at one stage you can say, "Are you know everything? You are wholly prepared with the case. Are thank you, thank you." Then you inspire him. So these are the things. These are the ways you can handle the situation. So on the very first date, this approach maybe may conclude the case. Then you will pass the judgment, okay. Here you have to do lot of research because every day we are learning. Every day, even on the same point, we have passed judgment, but on the same point again comes up before us, and again we read. And reading and reading, by reading and reading, we find we can innovate, we can interpret. Otherwise, no, that interpretation might be incorrect. Now, this is the interpretation which is correct. So, in this way, we can develop ourselves. You are very young, so devote yourselves. Read and read. Do research. And it will give a quality product. The judgment is our quality product. In many judgments, I have seen that on the same point, 10, 12 judgments have been referred on the same point. My request to brothers and sisters would be just refer one or two decisions, and you may refer other decisions. These are the only give the reference that this judgment has been followed in so and so, has been relied upon so and so cases. In this way, time management, you will dictate your private secretary voluminous judgment. So to write a voluminous judgment, you have to consume enough time, huge time. And the typist, you will give the reference only. Okay, quote, these are the paragraphs, okay, of the judgment. Just quote it and type it. But he is to type. Private secretary is to type. Private secretary is to type 30 pages only reference. So your work will be disturbed. Ultimately, he will type, give you. But your work will be, you cannot, because you have only one private secretary. So your time will be wasted. It may create a barrier to reduce the pendency. If it is a judgment of 20 pages, it will be typed very soon. You also dictate 20 pages, okay. And next judgment you can write. So try to refer 2 or 3 judgments on the same point, and you may write, because you know the references of other judgments. So you've been right. In these judgments, these points have been dealt with, and these judgments have been relied upon. Yesterday, my brother justice have said that we do not fear whether my judgment will be right or wrong, whether my interpretation will be right or wrong. We may commit wrong. I reiterate what my brothers said yesterday. But don't bother of these things. Ultimately, it is your satisfaction, and it will be your interpretation. You have interpreted the law in this way, honestly and sincerely. That is the crux. But you have written it, whatever mistake happens, okay. It may be rectified. For this, higher courts are there. We also commit mistake. Our mistakes are rectified by Supreme Court. So don't bother for mistakes. But we must be honest, without any bias. So script the judgment in this way. If you wrongly interpret a provision of law, no problem. If you wrongly interpret a factual aspect, no issue. So whatever you write on your own conscience, with all integrity and honesty. That will give the best result to you. Now, another aspect I forgot to tell you. A rule is in the offing. In a judgment, recently Honorable Supreme Court has asked all the high courts to frame their own rules and to incorporate some provisions to shorten the litigation, to carve out the time span. We have a rule committee. My brother justice is the chairman of this rule committee, and it is almost complete. I am one of the members of the rule committee. We have thoroughly, Shubhadeep has played a wonderful role in scripting the rules, and he assisted us very well, and so well that we have to make our own exercise very less. So thank you, Shubhadeep. The rules will be such that some provisions will be there that we at the before commencement of trial, we may ask the defendant whether there is any other party relating to the present suit which may have any interest over the suit land. If he says no, because the plaintiff may not know at the time of institution of the suit, plaintiff may not know. Sometimes it happens in the land disputes that land, I know as a plaintiff that land is belong to X, but X has sold the land to Y, who has not taken over the possession and who doesn't reside here. So how can I know the name of Y? So at this, on being asked, the defendant can say, yes, I was the owner of the land, owner and possessor of the land, but I sold the land to Y. Right? Then the judge will ask, he will ask, The land has been sold to why? Don't you know? Plaintiff will say, no, I don't know. Then the court may ask the defendant, okay, to please furnish his particulars so that plaintiff can implead him. So these are the cooperations is to be made and arrangements are to be made. And provisions are coming that before commencement of trial, we shall ask the we may appoint the advocate commissioner to identify the land, nature and character of the land, and even public notice also can be issued inviting the persons interested to the suit whether he has interest. Why this is so? This is so because after passing of decree, judgment and decree, we find the third person comes suddenly. Oh, I am not a party suit. I was not the party to the suit, but decree against I am possessing the land. I have been possessing the land since 60 years. Hurry, new chapter will begin. Now, after giving so much efforts, disposed the the case is concluded. Then again, during execution stage, again complications begin. So to avoid all these things, to avoid any disputes at the stage of execution, the object is of the Supreme Court's behind these directions is that to resolve the dispute at the very threshold, this kind of thing, so that this kind of thing, the courts do not face this kind of situation. Once decree is passed, it has to be executed in terms of the decree to avoid further complications, to stop this type of unscrupulous elements and the entry of any third party. These are the provisions we are going to make. So I think good days are coming. The pendency will be reduced. There will be expeditious disposal of the cases, which shall be efficacious and qualitative. So, okay. Thank you to all of you for giving me patient hearing. So, thank you all.
Thank you, Lordship, for your insightful deliberation. Indeed, monitoring the work of process server, filing written statement within time, and resorting to ADR could be some of the effective steps which can be taken for reduction of pendency. May I now request Honorable Mr. Justice Subhashis Talapatra to present his deliberation.
Today's topic is very interesting. This divided in three parts. And we hope that you had sound sleep last night. Otherwise, your memory will be a little bit here and there. And hopefully that the later part of the day will be also more interesting by the deliberation of the judges and yourself. And when I say that there are three parts in the topic, this one is a case management, another is quality disposal, and another is always a disturbing element is a pendency before the court. So we are taking up together. I personally believe that the audience that I'm addressing, they're more equipped than me regarding the case management. Because I had no opportunity to serving where the trial takes place. Even least I have practiced in those courts. So there may be somewhere I will be traveling towards the wrong direction. And during the interaction, you must point to me that that was not the correct proposition. And here, again, without fear, you must point out me. Because it is not the High Court judge. You are not the judges of the district judiciary.
Yes.
We are all in the same level because it is an academic discussion. This is I'm introducing because you should stand up where you have found certain difficulties where I will be deliberating, just frankly. But what I find through your judgment, I will give the reference to those things. But I tell that all of you know this. Where is the PPT? Just open it. Yes. This I will just start this that when Ms. Banerjee was introducing the today's topic, she mentioned one thing that Imtiaz Ali's case of 2017 of the Supreme Court. Uh, by that judgment, Supreme Court directed all the high courts that you just keep your data of the cases. It is not at all a case management purpose. It is for the data management. That is something very different. That I will come to slow by slow. Why data management? There is particularly the performance of the judges, the pendency in the particular court. Court has to decide regarding so many things. Why this is happening? And appropriate guidelines from the High Court should go to the district judiciary. That is the whole purpose. Before that, in 2011, there was a committee constituted by the Supreme Court of India wholly looking after the case management. There was 7 members of that committee from various layers of life, academicians, judges, and the law professors. They were just formulating a policy. They studied a lot of data, and ultimately that they are stuck up there because the data is so of varied dimensions. It's a huge country. It's a particular model cannot equally work in all the states. Even a model that will devise cannot equally work in the same state. So the model that I propose that should work in a particular court, then who will devise that model? Not us, but you. That is where the discussion starts from today. For every court, every judge is to decide what will be my model of case management. It is even not the district judge, I am telling you. It is entirely on you. And I will start with certain preliminary comments because Imtiaz Ali reminds me so many things. That our Anglo-Saxon and the Commonwealth, the tradition of management of the cases, from the day one is codified. That how to take the case to its end. And the CRPC, CPC, or the provision of the procedure has been provided in the special acts. These are the guide for the case management, the fundamental guides of the case management. And we cannot, perhaps going contrary to those provisions, cannot decide anything because we are bound by that. What we do, because there are 2 schools you all know. One, they are the votaries of the procedural laws. Apply it strictly. Decide whatever the outcome. Don't care for that. But there is another school, and perhaps I belong to that second school, that look into the substantive justice. 2001 Supreme Court decision, you all know. The procedural law is not MAD, MID, handmaid of justice. So what is the purpose of a maid? To serve the ends of justice. Not to subserve it or just to destroy its very spirit. Yesterday, Justice Mahanty was mentioning one thing. There is compassion in judge. Compassion can be shown by the constitutional courts to a larger extent. But it's very difficult to show compassion when it is a private dispute. You are deciding in the civil suits or the criminal case. Only where you can modulate things when you are determining the sentence. Otherwise, you have to strictly go by the evidence. No space for the completion. I am just introducing it because I have just shifted my onus on you, that I am not going to suggest you any particular model. I will say that for developing model in your court, what will be your duties and the methods that you might follow. That is important. And I say there is no equal formula for any case management. What happened is not working? Yes. Purpose of a case management is utilization of time. Whatever we discuss, this is the main thing, utilization of time. How we utilize our court hours, our time to write judgment. The time management is the process of planning. I'm coming to that. And exercising conscious control of time spent on specific activities, especially to increase effectiveness, efficiency, and disposal. The case management deals with all these elements. Now let us a little bit elaborate it. The process of planning. For a judge, from which term it started, there is certain beyond the case records that you have to also plan a process. You know your office, who is working where, how is handling the records, how the process server is functioning, whether he's diligent. These are all part of the case management. So you look into these human resources when you are planning it, and later on you come. First duty of a judge is to know his records. And most of the judges are unaware of their records at the initial stage. At the initial stage, if you are not aware of your records, perhaps you do not know, even you do not contemplate how you are to conduct the case. You know that this is the case I am holding. I will just certain illustration. In a criminal case, when a cognizance of a case is taken, it is the beginning of the criminal case. This is the first time. How the cognizance is taken? There are three sources under section 190. The court can take cognizance. Let us discuss only with the second example, that is from the police report. The police report is filed by the police. There are three parts. What are the three parts? First is the report itself. That is the opinion of the investigating officer. That according to him, the materials that he have enclosed with the report discloses a prima facie case under such and such charging section against such and such persons. So you first go through the report. Do you go through the records at that point of time? Anyone? I would ask the senior chief judicial magistrate, do you at that point of time, who are taking the cognizance, go through the records? I believe you go through the report. Don't, on the last paragraph, you only don't read that part. You do read the entire part. Anyone say that I go through the record? You go through the record, Shambhuji. Thank you for that. But I don't think at this stage the going through the record is at all necessary. You go through the report. You go through his description, because he is reporting to you that this is the supporting materials. You are not judging his report at that point of time. You are judging whether he has disclosed a prima facie case which can be taken cognizance of. Now, who are sitting in the rear, I believe that you are the juniors, because every year juniors are treated like that. They are given the rear. And I personally believe they should come first. They should learn more. Can you say that cognizance taken of what? Of the offenders? Huh? So you do not look at who was the offenders. But yesterday, one question raised that when taking the cognizance, that you find that investigation is bad. Some person has been let off, maybe against them the materials are there. So I'm correcting my statement now. If you are to apply your power under section 173 subsection 8, you have to go through the records also, whether the police, either by omission or deliberately, has excluded some persons who is liable to be brought inside this report. You are not taking whether he has actually committed the crime or not, but in letting off, not a part of taking cognizance, but to discharge that your obligation under section 173(8), you must check. Thank you, Shamodi. That is where you have gone right. So you have to look, because you are a conscious judge. You are not a judge completely going by whatever the investigating officer is placing before it. So for the cognizance, the law is that you only go by the record. Take the cognizance. Then the next stage, you are not finding any objection to raise under section 173 subsection 8. Then come the next stage. You are issuing notices to the accused persons, the sureties if he is not turning up. That part, we all know how to deal with that. Then come the question of framing the charge. So usually what happens? On the basis of the materials, you frame the charge. You discuss the materials in a very scanty manner when there is a challenge regarding someone's discharge at the point of time. And on prima facie, you may discharge, may not discharge. A law is a little bit of nebulous in this aspect. It is a more discretionary than as a specific law is available there. So thereafter the trial starts. I'm just showing certain part of the procedural law first. Whether before the framing of charge, the document placed with the police report can be admitted in the evidence. Any one of you, just assist me. Actually, I have not practiced, I have not also had the opportunity of serving that before framing of the charge, whether the documents filed by the police officer can be admitted in the evidence. Mr. Palith is saying no. I believe everybody supported this, no? Let us go to section 294 of the CPC. All right. No, this is not CPC. This section deals with no formal proof of certain documents. Just read. Where any document is filed before any court by the prosecution or the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused, as the case may be, or the pleader of the prosecution of the accused, if any, shall be called upon to admit or deny the genuineness of each such document when it has not been provided. The list of documents shall be such form as may be prescribed by the state government. Where the genuineness of any document is not disputed, such document may be read in evidence in any inquiry, trial, or other procedure under this code without proof of the signature of the persons to whom it purports to be signed, provided that this court may, in its discretion, require such signatures to be proved. Why do you come that before the charge it cannot be admitted? No, nothing. 294 is an open, gives you the wide discretion. Without proof, that will be admitted in the evidence. No, this is the without proof that you will admit in the evidence. So the admission will be the document not at the time of evidence. That is not the purpose of 249. Sorry. Then this provision will be unnecessary provisions, because you can do it at the time of evidence. Otherwise also, That provision has been created for different purpose. That to just ease out the problem at the time of recording of the evidence. Before that, you ask the parties that this is the prosecution evidence, this is the accused evidence. Do you admit this? Prepare a list. And at the time of evidence, yes. No, that's at any point of time. It is a wide discretion. It can be done also before the framing of charge. If someone opposes, no purpose. Usually, after framing of charge, I tell you, it will be very difficult. Very, very difficult. Then you have to go through the formal process. And another example, those who are the practicing in the civil courts only, what is the meaning of the first hearing? The case management, because he says there is a case management hearing. Yes. When? What is the stage of that examination? Written statement. Okay. Any other answer? Huh? That's obvious. That obvious. I'm saying, what is the meaning of the first hearing? Just, just I'm saying there is a development of law. That is why I'm pointing to you. At the first hearing of the suit, there is a Order 10 Rule 1. You are absolutely right. The court shall ascertain from each party or his pleader whether he admits or denies such allegations of fact as are made in the plaint or written statement, if any, to the opposite party, and as not expressly or by necessary implication admitted or denied by the party against whom they are made. This court shall record such admissions or denial. Right? So we are not going to the Order 12 for this purpose with the scratch of the parties. The court itself is doing this job. But the problem is that there is a one decision of the Supreme Court, Kanwar Singh Saini versus High Court of Delhi, 2012, 4 SCC 304. It says the first hearing of the suits comes after framing of issues whereafter suit is posted for trial. Said hearing can never be earlier than that fixed for preliminary examination of the parties and settlement of the issues. So here is a development of law. Supreme Court says not before the framing of issues. So why? There is a philosophy behind it. You know what are the real dispute in the suit, and you have ascertained that dispute. Then only you can make reference under Section 89 of the CRPC. So take care of this judgment. It is a. I am telling you, I am giving some illustrations. So always keep pace of what is the development of law. That our belief was that after the written statement is filed, that we can resort to the Rule 1 and Order 10. But it has been changed since 2012. So that I'm showing that Justice Lodh was pointing out there is no escape from study, and it gives you the required competence. That is the sword of a judge. All the time, do not be indolent. I know everything. World is now before my door. I am to address it only. That's not the situation. That your anxiety always must to do the right thing. It is not my word to do the right anxiety to do the right thing. Whose words can anyone say this? This is a very common thing. It is by Justice Denning. The judges has only one anxiety. That is anxiety to do the right thing. So to do the right thing, you know what is the right. And you have to do the right through the process of law. You have know that you are not like Qazis or other traditional judges, that whatever you think, that you can do that. Yesterday I was saying what will be the judge's character. Now what judge will do. And judge's only principle in Dharma is to do the right thing. Right according to the law, according to the equity, and according to the compassion. Treat human beings as human beings. There's a lot of follies lot of weaknesses in their character. All weaknesses are not having the malafide intention or the mens rea, right? That you are to identify this. You are the only person. That is why when we are coming in an age of artificial intelligence, that you must also understand that what is this artificial intelligence? They can produce a judgment. It's a reality. If you just fit plain written statements, your evidence, documents, and the arguments placed by the party in written form, it can write a judgment. And it will write a judgment according to law. So, what is the difference between a human judge and artificial judge? The intelligence cannot take care of these many facets of human life, and how that particular human being has reacted in a particular human situation. It will be impossible to grasp by the very intelligent, but they can settle so many disputes where this application of this human mind is not required. As the dispute relating to the Facebook is being now adjudicated by a artificial intelligent adjudicator, robo judge, they call it a robo judge. They are doing it, and people are happy with that system. So this is one of the planning start from the beginning, and the first step of the planning is to know your records. There is no other alternative. Second, you plan the stages, a tentative timetable, when the train will reach Patna, when in Agra, and when in Delhi. And we always criticize the train or the railways when it doesn't reach the platform such. Just face the same mirror for just for your case management. You say that these the things. I was visiting in Washington court, the civil court, because their system a little bit of different because they are not following the Commonwealth tradition. That the judge invited me. Two of us actually visited of our own, knowing how their system operates. So fortunately we are there when a meeting between the lawyers of the parties and the judge was being held. So he says, please wait and see what we are doing here. It's okay. The lawyers were taken into the confidence. The same, they have also the procedure. You know that their code, the procedural code is formulated by the every district. Not there is no central code. So according to the district code, they are just holding this, they call it the case management meeting. How the trial would proceed. They are just settling the dates. Enter. When the evidence will be there, everything, dates are completed and order is passed. And it is an agreed date. Expectedly, until serious thing happens, they will not deviate from it. So they know from the day one when the judgment will be pronounced for the particular case. Can we just follow this to a little extent? You give a think over that, and that will be the part of the case management. In earlier, the sessions trial, it was rigorously being followed. We call this a calendar of trial. Particularly, these are for the examination of the witnesses. That such and witnesses, and lawyers, and we have a habit, even just take leaps on that calendar. It is topsy-turvy. Again, start from the beginning and phrase it. Whenever, sometimes exceptional cases are always there. This is always exceptional. But as far as a practicable, when you be required to leave or the plan, family and everything, when you are just finalizing a trial calendar, you just think of your personal also preoccupations that might appear certain times, and accordingly that, so that it is not jeopardized. That is very important. So this is one of the way, and the conscious control of time spent. That, suppose I just give one small example. Nowadays, it has become a fashion that when the issues are framed, the lawyers are not taken into the confidence. It is, in a way, it is not the lawyers, any role is there according to the code. You bring the lawyers and give your draft issues, not the lawyer draft issues you receive. You just provide a copy of your draft issues that you're proposing to finally order. Let them say over this on the spot itself. You might miss an issue for whatever. You are stressed, or maybe that when reading, sometimes we miss certain lines, certain things where grain of a dispute is there, which can be separately dealt with. So if they suggest a new thing, say, right, you should include it. If certain frivolous issues is proposed, you just discard it. You finalize it. If you can carry the lawyers along, then the trial becomes much easier to be conducted by a judge. So every part, how much of time you will be spending, also plan that part also. I will not allow this much. Suppose what has happened, what we have done, the judiciary has done to these orders happened in Rule 1. Just tell us that what we have done it. That it was there the maximum 3 times at the time of hearing. That is when the evidence is being started recording, 3 times will be provided. Now we have made it a discretionary, meaning the entire amendment that was brought, we have made it as a negated. And when Supreme Court says the court will decide whether certain further time will not be granted, though in tune it is discretionary, but in a reality, that is not a discretionary. This is an extra amount of pressure on the judge. The lawyer will come and say, why will not give, sir? The law is not mandatory. As if law is not mandatory, the judge cannot decide anything. Whatever the decision is there, you always decide that whether the adjournment will be granted and whether the grounds for adjournment has been made out. And when I'm talking about the grounds of adjournment, I'm aware that a advocate's class file an application, the lawyer is ill, and we accept that application. That practice should be stopped. Because now, after amendment of the CPC, every application where a fact is pleaded, that ground of adjournment is based on a particular fact is pleaded, that must be supported by an affidavit. If you can insist that according to law, the number of infringement, I can tell you that it will come down to 25% will be avoided, because to bring the client and file an affidavit, better we can do it. So, if the rigors of law is followed, I say the courts are the instrument of the case management. So we have to follow that. Sometimes, yes, here and for the substantive bench of justice, we make elbow room, so that the justice can enter at least. Justice should not fail. Justice cannot be frustrated. The other part is that increase this efficiency and disposal, efficiency of particular judge. Every step you just discharge your duties. And the disposal must be qualitative disposal. I will not advise on that. Because personally, I believe a judgment is a reflection of a personality of judge. Not a persona of a judge, a personality of the judge. How you would write a judgment. Because how to write a judgment, Order 20 is provided there. This is how to write a judgment. One judgment by Justice Madan Lokur starts that in view of the evidence that we have gone through and read, the accused be convicted. This is the first line of the judgment. That is of the Supreme Court also. Then, next paragraph, why we have decided to convict the persons are for the following reasons. So I cannot say there is a model of writing judgment. But of course, the CPC provides a structure how to write the judgment. Basically, the judgment as defined in the CPC is a statement of the reason for giving the decision in a particular case. Apart that, nothing is required. Now, how you will present your facts and reasons and your conclusion, it will depend entirely upon you, not to anyone else, entirely to your satisfaction. Whether you will write in support of a 1.2 paragraphs or you write 5 lines, it's all depends on you, up to your satisfaction. As Justice Lodh says, nobody's satisfaction but your satisfaction. So where from that quality you come writing the best judgment? Number one is from your experience. Number two is from your knowledge. Knowledge of law, knowledge of the facts that you are deciding. And number three, your skill of reasoning. The two things are completely unidentified. One is experience and the skill of reasoning. And those two elements are completely interlinked. We go through the different experiences of life, not relating to the law. It contributes to our skill of reasoning. We pass through the harder times of law. We give the best trial of our intelligence, how to make the survival. So if you do not go through these, the hardest days, perhaps the certain part of your faculty of skill will never be open up to help you out. So the experience grow with several situations. That some very young boy, maybe very experienced in certain area, maybe in your older age, you also will not have that experience. You may not have that skill. So these are very relative issues, but always keep open. Look at the other people experience that we gather from the judgments. Look at the other people experience that we get through the witnesses, because we say the witnesses are our ears to the situation. Very carefully listen to what is believable and what is not believable. Now this other slide, I have very few slides, that it is the key 7 factors of the successful change management. Everything is for change. That is called it is a change management. Management word is not very akin to our the profession, but everywhere it is now then. First of all, the plan I have already discussed. Before undertaking any change, a business needs to have a clear and valid reason and mission for the change processes. We are in the business of judging. Right? So you must plan according to that. This other is the communicate. Your plan not to be on the sleeve of your bush shirt or any dress. You have to share with the entire team. You have to communicate with the entire team. This is my plan. This is how my court will run. That is why it is a unit where you have to give the case management. Take along everyone. Communicate to them that what you think, what is your mission for changing the system. Second, to integrate. Integrate everyone in the team who is required. Identify their particular role. Integrations not mean bringing everyone together, bringing everyone's relevant roles together. You remember this, that is very important. Then motivate. You are the leader. You have to motivate the entire team to work for sincerely, diligently, and effectively. Then be confident. Confident who? The leader must be confident that it will work. He knows his plan is so well researched and it has been tested through the little experience. So be confident about your scheme. Wherever the necessary changes and modulations are required, you do that. Then there are the manage the workload. That is the important part. Sometime one day you say that you have listed about 12, 13 cases, out of the 3 trials. It's a frailty in exercising your, and you cannot do that. So distribute the workload in a very systematic manner that you can shoulder it. Otherwise, you will not deliver anything which is expected in a particular unit of day. That is why I was pointing out how the time will be spent. That is very important. So plan it accordingly. And the last is the most important part, that evaluate so far what I have achieved. So that is very important, evaluation. In any management, this model, that is very important. This is now I am showing certain things. This is what we have done so far in 2021. This is the results. You can see the 21, every court of the West Tripura district I have shown. You can show the first column in every this blog is the institution of the cases during the year. The first the column, because you don't read. These are a lot of information is there. Second is disposal in the mid, which the column is the disposal, and the last one is the pendency. Now you can see the situation. That what is the situation? It's a graphical representation of the every court. This column, this side, the extreme right side is the institution of the case and the number of disposal 472, and thereafter the balance, that is the 932 in 405. I'm not naming the code. 405, 472 is the disposal, higher than the institution, appreciable, but still the pendency is 932. The column shows where do you really stand in as regards the pendency. Just you see, always this column is much higher than the other columns. And sometimes disposal is also less, it is there. This is another, the same, just you see, that there is a one court, just see, two court, three courts, their pendency has become much lower. Just see. This is the result of the data analysis. This data should be analyzed in every court. That we are analyzing for far of your courts. This is the situation. Just see. The two courts are there. In one course, pendency is almost equivalent to this institution of the case. It's a wonderful performance. Just see other courts. The pendency is much lower than the disposal is also much higher, and pendency has come down. Now, what is the ultimate result? It's a unique thing. That is the month-wise disposal and the graph. Do you see the huge valley in between the two hills and the valley? The period is from April to September. Can you say why this has happened? So, the lockdown, right? Let's see this every court this has happened. Now see the same way. There is a Gumoti district. In some courts, the disposal is very low. These are for your benefit. That every graph for the all courts of Tripura. So you use this information about the pendency for planning a change management. That how can we do that in every court, and information where the information available is CIS, National Judicial Data Grid. These informations are available. You analyze it in your own court. This is the Gumoti. Just see the situation. The institution is much less, a little bit better is disposal, but pendency is the tip in all the courts like that. This is the situation in Gumoti. But the time is different. It is May to July. It has come down to that. And again, it has come down to October and November. October and November, you have seen in the other courts, there is disposal is higher. But in the district of Gumoti, it has come down. Why? Yes, that is uniform throughout the years. That we not only enjoy the holidays, we extend our enjoyment for far more years. We just wake up from the enjoyment. So just take care of this time management also. This is South Tripura graphs. Brother Gore is there. It is his portfolio district. Just see the one court, the pendency has been substantially lowered. We appreciate it. This is the situation. This is the South Tripura overall things. Just see the pendency is lower than institution in a particular year. Wonderful job. This is the situation. Same. This Dharmendra says that it is for the lockdown period. But that second value is not for the lockdown. It is for the extension of the enjoyment time. Right. The same I'm just through. This is Unokoti's situation. This is the columns showing this disposal, and the institution is much higher than the disposal, and the pendency suddenly has come down. Just see the scenario. From the month of February to the month of June, it is going down, down, and down, partly for the lockdown. Entire time was not under lockdown. Then that the enjoyment extension, October and November, is common to everyone. This is not Tripura. I am just now skipping. Just the same thing. Just same the situation. This is a very unique thing. This is a May to the August. That from May the disposal was 233. In the month of July 234. In the month of August that was 234. It's a level. No, they are not in a way to grow up. No, we'll not grow up. We'll sleep for certain thing. See the same thing in the month of October and November. Some parties, of course, under the vacation, there should not be any disposal, but the extension period is of our concern. Right. Just I skip over, it is Sipaijola district. Just see the graph. It starts from April to August. Then that period is common, I say. You take care of all these informations that is available. So I conclude, I will not take. I think I have given a grain of my idea what to do about the case management. Please take record. The time spent must be shorter as possible. For that, you can innovate the ideas within the parameters of the codified laws. Don't break it. Otherwise, your order will be challenged. And it will just again stick up the case in a certain point that you won't like. So do it. That just a question for you. I believe you are the change. The answer, can you make the change? It should be come from you. Can you make the change? Hopefully, the change will be witnessed April to December this year. Thank you, everyone.
Thank you, Lordship, for your insightful deliberation. The House is now open for interaction.
Take presumption, particular fact. Now, my question is that at which stage of a case or suit we are to take that presumption?
Of course, when analyzing the
Evidence.
that there cannot be any other alternative time in that.
Right.
Because I'm telling you, on section 4 is not for purpose of taking presumption. Just a little bit correcting. It is the presumption. Sorry. It is the presumption vis-a-vis the burden to disprove the presumption. Section 4 provides that power, that other party has the right to rebut that presumption. So after that stage, Section 4 gives the opportunity to the opponent to rebut the presumption. If there is a situation is created that you can draw the presumption under statute. Mostly this statute deals with the presumption, and generally we get that power for Section 1 and 14. General power of presumption we take. Other certain statutory presumption in certain particular fact that has been provided. But Section 14 is not the end of the journey for presumption. Then it gives the power to the opponent to rebut the presumption under Section 4 of the Evidence Act. So when it is done, it is after the end of the evidence. When you are analyzing the evidence, whether you will presume or not, you will decide that.
Now,
First
my
of all,
lord,
when there is a hard fact, there is no necessity of presumption.
yes, my lord. Now, the definition of may presume speaks that court may presume a fact is proved or may call for further evidence.
Yes.
Now, if I go at the go for taking presumption at the time of analyzing of the evidence, that is at the time of judgment, if I at that stage, if I see that no presumption cannot be taken, should I go back to the stage of trial?
You should go back. That if you come to this situation, that is a discretion given to you whether you go back or not. Nobody is compelling you. That is like 330(11) of the CRPC. That whether you will exercise that power or not, nobody can dictate you. Only whether it is required for you writing a judgment or not. So you have to call. If you say that certain evidence is there, who can provide the hard evidence? Presumption is always unsafe. I'm telling you. So you will always find out that hard evidence. so that your reasoning is based on the hard evidence. That's
Thank
already
you.
say your discretion, you may call. Because I says that I belong to the school which are these votaries of doing the substantive justice. We should look into the justice is not failed. That's all, Mr. Yes.
Thank you.
Being appellate court, I find presumption should not be taken, trial court taken. Then what?
Yes.
Being appellate court, trial court has taken presumption, but being appellate court, I find presumption should not be taken. Evidence should be followed. Then what? Again, you will say.
That is because you know Order 41, Rule 27 is a little bit of very, very some parties gray areas is there. You can accept this. What is very difficult is there can receive evidence in that stage. When the word receive is used, it creates a lot of barriers. But I personally believe if you see there's a possibility that to avoid the presumption, there is an availability of the hard evidence. You can, with the parties, can call the evidence. There's no bar. Because when there is no provision, you can apply the provision of Section 151 of the CPC. Because you need, because first appellate stage, the reduction of the additional evidence is permitted under law, right? But you should do that because when this is a gray area in the procedural law, except in exceptional cases, you should not exercise that power. That's my personal belief.
Good morning, Melu. Melu, few days ago, my bench clerk placed one case record before me and told me that it is a long pending case and it is pending at the stage of ER. And we have received report from the police that warrant is not executable because charge sheet has been filed against national. Case was registered under section 489B, 489C of IPC. Then I perused the record and found that before submission of charge sheet, the accused was released on bail on execution of a bond of rupees 10,000 only with one treaty of like amount. And then the accused was released. And when charge sheet was received by the court, notice was issued to the surety and he appeared before the court and expressed his inability to produce the accused on the plea that is a Myanmar national. Then court forfeited the bail bond and the surety has deposited the forfeited bail bond money. But now the case is pending before me at the stage of EI. My question is, we know that a court of law is not the issuing authority of passport and visas. Now, can a court of law can release a foreigner accused on bail without imposing any stringent condition and without giving any notice to the Home Department of a particular state or the local administration? This is my question, Melvin.
Anyone to add to this question or anything to add? This is a very peculiar situation in some cases of our state. Can anyone suggest those who have worked in the bordering states, they have yes. Oh, but, those who have in the bordering subdivisions, they have certain problems of this, like yes, Dharmendu.
My lord, actually, in other states, basically in Assam, there are some detention camps are there. But in our state, there is no such detention camp, so that foreigners can temporarily be lost there. So if
Dharmendu, this is a completely different issue. Their foreigner tribunals are identifying the residents of Assamese who are, according to them, the foreign nationals. They are to be just to their own homeland. I do not know what is their homeland.
no, thing is that, my lord, once an accused who is prima facie a foreign national, suppose he has also some identity cards of foreign national. Thing is that he has entered India illegally. So we cannot allow him to roam around, because if we release them on bail, then he will roam around because in indirect manner we are indulging him to be in the India. So best thing is that if matter is taken up by the Home Department and
Can you just give one example from Assam state that a person who has not been legally declared the foreign nationals and entered into the India without any legal document has been detained in the detention camp?
yes, under trial before declaration of that nationality, they are detained in
And
the.
do you know what is the observation of the National Human Rights Commission on that aspect of the matter?
No, this is adverse remark.
Yes, absolutely against the human rights. I have not been found as the foreign national. I am the put into the detention camp that we cannot. You are absolutely right. The government should find the solutions to that situation. That when we cannot push back someone who has been declared by the court as a foreign nationals and entered into the Indian territory with the proper documents, where they will be placed? They can be only the repatriated to their country.
Yes.
And you know what is the repatriation mechanism is entirely is an executive functioning. The external affairs minister will take up the issue with the concerned country, and then because we do not have the repatriating agreement with all the countries.
My lord,
Even
there is SOP is there one.
standard procedure doesn't have any legal sanction.
Yes.
That is the whole difficulty. You have to approach to the executive authority time and again.
Yes.
If there was a repatriative mechanism, then you can send to that authority to repatriate that. That we are in a nebulous situation.
Yes, my lord.
Because we have already taken up the issue, because you know that I am the chairperson also of the Juvenile Justice Committee. There were 7 foreign national child were staying in our special home. So order passed by the JGVs, they will be sent to the respective countries. Order is wonderful. We have now discussed, but how to send them there? So we have written to the External Affairs Minister, waited 3 months. Then I met Justice Lokur at that point of time, the chairperson of the Supreme Court Juvenile Justice Board. Then Justice Lokur said, wait. In his chamber, Justice Lokur called the Secretary of the Ministry of External Affairs. He promised that he will just take up the matter, but he could not take up the matter because the issue is so intricate and involving in the other countries. We cannot unilaterally take decision. We understand that.
My lord, I faced another difficulty.
Yes, no, just here. What is the outcome of that? Now in the every district magistrate office, there is a advisory has come. Whenever such situation arises, they should immediately report to a particular cell of the External Affairs Minister, and they will take the appropriate action. That is the development so far.
My lord, while I was posted at Agartala, one Nigerian person, Nigerian or Uganda, somewhere, he entered India with fake visa, and he was tried. After on conviction, I sentenced him for 2 years or 3 years imprisonment, and directed the jailer to make necessary arrangement for his repatriation after sentence is suffered. Then they communicated with the Home Department and Foreign External Affairs. Then, in the meantime, his sentence was over. Then he came to me what to do. Then I said, these are administrative matter and policy of government. As a judge, I cannot pass any order on that. So ultimately, they kept that Nigerian person at juvenile justice.
I know that. Yes.
In a board. Subsequently, he was sent.
And when he was sent, he was no more juvenile.
No, he was not juvenile, my lord. He was an adult person.
He was not juvenile, but he was kept in the juvenile home.
Yes, my lord.
That is happening because we cannot help it out. This is beyond our capacity and jurisdiction. Yes. Any other question? Otherwise, we can close this session. Don't ask me serious question, then I will divert it to Justice Lodh.
It is regarding only for unit of disposal case. One case actually it is in my mobile, so I have to see.
You are digitized your cases in your mobile.
No, it is related to High Court order number 41.
Yes.
Administrative order, unit of disposed cases. Date 20th July 2013. regarding
because
regarding cases on atrocities on SC/ST.
yes,
It is unit given only 3. So here is my point.
no,
Why it is only for 3? Because in ST code, my means sessions code, I am dealing one case of SC/ST just newly come up to my code. So I found that unit is only 3, but in all cases, unit are 6, 8, or even 12.
no, this
So
is true.
it should be, please look into the matter.
You just
That is my request.
this matter. Because it is because
It should be minimum 8.
no, just yes, I agree. That is why I'm going to take the note, because the complaint is filed before that particular course and entire trial is taken up by this court. So disposal takes a lot of time. It should be higher unit. He is absolutely, I take up that issue because it's a full court matter. Any other question?
My lord, may I?
Yes.
My lord, thing is that in criminal cases and in some civil cases, what I face regarding disposal, my question is regarding disposal of cases. Whenever I send summons or sometimes warrants outside my jurisdiction, that is beyond beyond of my state, then I hardly receive any report. So, my lord, some to ensure that the executing authority they receive the summons or warrant, whenever I send those summons outside state, I send it by registered post. So that registered post, but hardly I get any response even after reminders, repeated reminders.
So we are doing in the High Court, I tell you, I have started doing that because never the what we call the acknowledgement due card never reaches the Nazarat or the registry. That
No, my
is the-
lord, not about acknowledgement. I just get it confirmed through postal track that they received
Ah,
the but
then
despite
what is the further problem that it has to be deemed to have been served on them? Because it provides under Section 24 of the General Clauses Act. So nothing doing that, and moreover, this Rule 5, Order 5 Rule Rule 9.
Inserts.
Yes, that is in tune with the General Clauses Act of Section 24. No, should be correct. That should be ascertained that it is a correct address. But that this is a system that technology has provided us. India Post website. They completely says the registration number you put in, and that even it was not delivered, at what point it is stuck up, they can also show it. So in the High Court, we are now accepting it because there is no other alternative. There is no other alternative because we believe, because they are the persons who are delivering these registered articles in the name of the addressee. Yes.
warrants directly to the person concerned, summoning.
Yes.
I send it to the SP because as per section.
Oh, you are talking of the criminal case?
Yes, 67 CRPC, it has to be sent when summons are sent outside jurisdiction, it has to be sent to the SP. So
Yes,
accordingly, I send it to the SP. Suppose Assam, West Bengal, Bihar, I hardly receive any response from them. So in that case, if in each and every case I take cognizance of that fact, then it will be very hard for me to proceed with other cases.
There is no easy answer to that.
In that case,
Obvious.
cases are struck.
I understand that if the SP is not working, write a letter to the High Court. I am telling you that we have done it earlier. That these are the cases where the summons sent through the SP, we are not getting the report, right? Then we'll take up with the DGP state, and he has a dialogue with the DGP of that state. That is, we are just in the ring side of the problem. We are working to the ring side of the problem, and they talk, and the matters are a little bit progressed. But there is no easy answer to that. This, to be very honest.
When we send it to their email ID.
Right. If you can collect the email IDs, I think that interoperable, this mechanism that is being developed throughout the country, that will be more convenient for our judges to work, because they will provide all the email IDs up to the level of the police station. Then you can, yes. That is why I tell you have to innovate. There is no easy solutions to that. In extreme cases, you can write to the High Court giving the particular name, someone in which date it was sent, registered letter numbers, everything. We can request to the DGP police to just take up the matter with his counterpart, and that only this way, because there is no easy solutions to this.
My lord, actually, I'm a bit hesitant to ask this question.
The last question, yes.
My lord, I'm a bit hesitant to ask this question, but I think it is the right time to raise this question as the rules are being framed. In private criminal complaint case, generally the learned counsels get the summons prepared and submit to the court. In GR case, it is the different thing. It is the staffs who are preparing the summons and courts are issuing the summons. Then my question is why it is different in GR case? Because it is the duty of the public prosecutor and the learned APPs to prepare the summons and to submit before the court. So I held the court in Udaipur and I saw this. I don't know what is the practice in other court. So as the rules are being framed now, so can there be any rule that it is the prosecutors who are to prepare the summons and to submit?
Do you know one thing is common parlance in the Commonwealth tradition is that called the principle of the court practice, right? In some courts this is practiced, in some courts this is not practiced. And what is the root of that? It is the legacy, pre-1973 legacy, and we still treat it as a court practice. Earlier there was no division of these judiciary, and there the executives, designated executives used to riot. So they think that it is the part of the same machinery. You can insist there is no difficulty in that. Because law, according to law, they should issue the summons to their, through you, of course, they can apply through you, through court process, you can send summons. But whenever it is the court witnesses, then the entire duty lies on you to serve the notice or summons to that particular witness. How it will take 5 minutes time, because we are giving the computers in the court offices. To prepare a template and just put the name and send it, preparation, hardly take 5 minutes time. Don't show the issue of the time, because if you say the process is as such, it should be done by that. And our experience in 1 or 2 cases, when it was done by them, it took much time. And if you do it, you know how to control your own time. Don't leave to them. I will suggest that. Continue with that. Because we know what is the situation in the public prosecutor offices. They are ill-staffed. They do not have the proper staff also. So better let it continue. We'll think later on what can be done. Thank you, everyone. Thank you for giving the question.
With this, we have come to the end of this business session. I request one and all to join for the short tea break at the Judges Lounge. Thank you.